If you're thinking about skipping immigration court, I want to tell you lots of positive success stories to help you kind of put that idea out of your mind, get ready to go to immigration court, and really understand what to expect so that you don't find yourself basically in a somewhat irreparable situation. Hi, I'm immigration lawyer Hillary Walsh. I'm the owner of New Frontier Immigration Law. We're one of the best immigration law firms in the US, if I do say so myself. And we serve a lot of immigrants who are in removal proceedings and they have to go to court, and it's really scary. I want to really emphasize how scary it must be to go to immigration court. And here's my real honesty and vulnerability with this is I've been an immigration lawyer for over 10 years. And even when it is basic immigration court hearings, I still get a little nervous. And it's because there's an element of unknown when you go to court. You don't know if the judge is going to be in a good mood. You don't know if the government attorney is going to be in a good mood, if they're going to be nice. You don't know a lot of things that are outside of our control. And as an attorney, and absolutely, I can only imagine as an immigrant, you really feel that stress. And you will probably not sleep the night beforehand, even if the attorney says that it's no big deal, it's not a big hearing. It can feel very, very stressful. So I want to just start from the place of, I can't say that I get it because I have never been where I have to go to court because I'm facing the possibility of being deported. I would be lying to you if I tried to say I get it. I don't get it. But what I can say is I have gone to hundreds of these immigration removal proceedings, these immigration hearings with different clients, and it's stressful. But for the most part, the same couple of things happen at every single hearing. And what I want to do is kind of walk you through what those things are going to be. If you have what's called a master calendar hearing, you'll know that it's called a master calendar hearing if you go to the EOIR website and you type in your A number. Your A number is going to be on any of your immigration documents. So if you have what's called a notice to appear that tells you the time and day and the address for where your hearing is at, there will be like an 8 or a 9-digit number, usually 9 digits, following the letter A. And that's your A number. It's kind of like your social security number, but for immigration purposes. It's your unique identifying number for immigration purposes. If you Google EOIR, Executive Office of Immigration Review, automated case information, EOIR automated case information, it's going to ask you for that A number, and you just type it in, you click OK, and you go from there. It's going to tell you when your next hearing is and what type of hearing it is. It will say master calendar hearing, or it will say individual hearing. Those are the two most common types of cases where you're to know what you have to expect. If you're in removal proceedings and you're detained, like let's say you're looking this up for your loved one and you're trying to figure out what kind of hearing does he or she have, if it's a bond hearing, that's not going to show up on the EOIR automated case information. So if they have a bond hearing scheduled and you know that they have a hearing tomorrow, but there's nothing on that website, it's probably because it's a bond hearing, and bond hearings are not listed on the main case type website. It's kind of weird, but it just is what it is. So you're going to see master calendar hearing, or you're going to see individual hearing. A master calendar hearing is really a calendaring. It's very administrative. They're just going through making sure that the case is being set up and it's moving forward in the way that it's supposed to. Essentially, it's like managing the project of deciding whether or not you get to stay in the United States. And so they need to make sure that all the evidence is submitted by a certain date. They need to make sure that the government is doing what it's supposed to be doing. So it's not like stalling out the case that maybe you shouldn't even be required to show up for. So it's basically the judge managing everything as it moves forward. And the attorneys are then held accountable and held responsible for getting done what they promised the judge that they need to get done. And if you're representing yourself, then you're responsible for getting those things done when the judge tells you to get them done. So if you have a master calendar hearing, here are the common things that will happen. If it's at your first master calendar hearing, this is your very, very, very first time that you're going to go to court, the judge is going to go over what I would call an advisal, which is like a fancy word. I don't know why, but they're just going to, I don't even know if that's a real word now that I think about it. Maybe it's a made up word, but they're going to advise you of what your rights are. You have a right to an attorney at your own expense. If you file a fraudulent asylum application, this could basically haunt you like the boogeyman for the rest of your life. They're going to go through these different, basically letting you know what your rights are in immigration court. And that's a document that they read. It's just very long. It's like 3 minutes long where they just read it and they tell you all of your rights. And then they say, do you have any questions? And you're like, you just talked to me for 3 minutes. I don't have any questions. Okay, so that's what's going to happen at your very first hearing. And then the judge is going to ask you, like they're going to ask the government attorney, usually if you're by yourself, they're going to say, okay, DHS, what is it that you need to, what are we doing here? And they're going to ask the government attorney what's going on. And the government attorney will then respond to the judge, and the judge will ask you, hey, do you want more time to find an attorney? Are you looking for an attorney, or do you want to represent yourself? And it doesn't really matter what your answer is. You can always, if you say, you know what, I want to represent myself today, you can always bring a lawyer later. Or if you tell the judge, hey, judge, I would really like some time to find a lawyer. Can I have some time? The judge will usually definitely on that first hearing tell you, yes, no problem. And then if later on you decide, I don't want to have a lawyer, I want to represent myself, you're not going to be held to like that rule. Like whatever you say right then is not going to you're not handcuffed to that decision forever. You can change your mind because you do have a right to a lawyer. You do have to pay for the lawyer unless you have what's called a significant mental disimpairment under what's called a Franco case. And then the government will provide you an attorney. Okay. So that's really the basics of what happens at your first hearing. It will take maybe 10 minutes, and the judge is going to set a deadline for you to find an attorney and for you to come back for your next hearing. Again, this is just the judge wants to keep the case moving along. And if the judge doesn't put anything on the calendar, the case is going to get lost. It's going to disappear. It's going to fall through the cracks, and it could be 15 years and you never have another hearing, right? And a lot of people want to have their hearing so they can get their case moving forward and hopefully get their green card. Okay. At your second hearing, if you don't have a lawyer at that, you can ask for the judge again. You can say, Judge, I would still like more time. I'm still looking for a lawyer. But the judge is going to be less likely to, I would say you'll get maybe a 60% chance with most judges for a second chance to say, hey, I don't want to do anything. I want to find a lawyer. I bet a small majority of judges will give you another hearing. A different majority of judges will tell you at your first hearing, and they'll say, if you come back, sir or ma'am, if you come back and you don't have a lawyer, I'm going to expect you to proceed on your own. I will not give you another extension. That's what most is. Like any judge who's going to be really strict, that's what they will usually say to you, okay, at your first hearing. So you'll kind of have an advance notice of what's going to go on. But at that second hearing, if you've been looking, if you hired someone and they're just not there, like you don't know what's going on, you can ask, hey, I know I already got an extension, but I would like a little bit more time to try to find a lawyer because I don't know what I'm doing. And this is making me really nervous. And I want to do a good job with this judge. May I please have a little bit more time to find a lawyer? And most judges will say yes. However, there's that 40% or that other large minority that will say, no, you need to proceed today. And that's going to put you in a really sticky situation because now you're going to start having to talk and make statements that will be with you for the rest of your case. And they are statements that basically cannot be undone throughout the rest of your case. Things like, do you admit what the government has said about you is true? Do you want to be deported to your home country, or do you want to designate a different country? Things like that, once you say certain things in immigration court, they cannot be undone. Whether or not you want a lawyer, that's not one of those things. Whether or not you admit that you are here without permission and you entered on blank day EWI or entered without inspection on blank day. Sometimes, those things are things that you wish you had not agreed to, and then you're stuck with them. And that can really be problematic in the long term. And frankly, those are the reasons that immigration lawyers get really nervous at these second and third hearings where the judge is going to ask the attorney to enter pleadings, because once what's called entering pleadings, saying, yes, the government has either done what they need to do and they have proven it and I admit it, I should be deported except for this other reason. Even as lawyers, we know that once the toothpaste comes out of the tube, there's no putting it back in. And so that's why I would get a lawyer if you can't. But if you can't, if tomorrow is your hearing and you're like, I do not want to go, just go. It's okay. You can ask for an extension. If the judge won't give it to you, you're going to have to just do your best and it will be okay. We will figure it out. Okay. At your third hearing, you're definitely going to have to enter pleadings. And that's where you admit or deny what the government is saying about your removability, whether you're a lawful permanent resident and they're trying to take your green card away, or whether you have no status and they're trying to deport you. You're going to have to answer the questions at that third hearing. I would say like 80% of judges they're not going to mess around. They're going to say, all right, we're here for the third time. It's time for you to enter pleadings. And they're also probably going to want you to provide the completed application for whatever form of relief it is that you're saying you should get to stay in the United States because of this form of relief. So let me give an example. If this is your third hearing and you're here to seek asylum, you're from Guatemala and you were allowed to pass through at the border and they gave you a notice to appear at the border and this is your third hearing. Number one, you have to file your I-589, your asylum application, within 1 year of arriving. So even if the judge has not told you, hey, by the next hearing, you need to complete this, Congress has, the maker of all of our laws has said you need to submit this to the court by 1 year of arriving. So it's very important, whether it's the court or if you need to do it with USCIS because you're not in removal proceedings, you have 1 year to do it. Now, if it's like a 42B application, it's a little bit more to submit these because you have to pay a filing fee to a separate government agency called USCIS. And then you can file the asylum application with the court. Not the asylum application, the 42B application with the court. You have to file a filing fee with somebody else. It's kind of wild. You're going to want to do that by your third hearing because number one, you can get your work permit after you file your 42B. You start the clock on being able to get your asylum application after you file it. Like there's a lot of incentives to go ahead and getting the application filed. If those are all master calendar hearings. Usually at your third or so master calendar hearing, the judge is going to tell you when your final hearing is. And your final hearing is something called an individual hearing. That's your final hearing. That's it. That is your removal hearing where they'll usually set about a 3-hour time block for you to present evidence, for your lawyer to present evidence. The government will ask you questions. A lot of times the judges will ask you even more questions than the government attorney will ask you. It is a very intense day and it's a really important day. If you have an individual hearing and it's coming up, you definitely want to work with a lawyer to the best of your ability. So if that's on the horizon for you, you should do that sooner rather than later because most judges will require you to submit all of your evidence in support of your case about a month, 2 weeks to a month before your actual individual hearing. So if you see you have an individual hearing on March 1st, your deadline is usually going to be around February 1st to the 14th for submitting everything to the government. Each judge kind of varies on how he or she wants those documents, when he or she wants those documents submitted by. But anyway, if you get too close to the hearing, there's like nothing that you can really do. So don't put off for tomorrow what can get done today. Figure it out today. Call a lawyer today. Call me. I'll help you. We'll do our best to help you, especially if you're in Arizona. Okay. If you see that you have any type of hearing, master calendar hearing, now you kind of know like this is all the administrative side of things, like getting all the ducks in a row. An individual hearing is where it's like, I'm just talking to you about your actual case and you're going to prove to me why you should get to stay in the US. Those are your two main types of hearings. If you no-show any of them, the judge can and most likely will order you removed in absentia, which is the Latin term for in your absence. So even if you're absent, the judge can order you removed. And then that just creates so many problems for you. And we don't want that. So what you want to do is never, ever, 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 in my opinion, skip an immigration court hearing. It's like such a problem. So move mountains. Be on time also, because they can order you removed in absentia if you're even 1 minute late. So, and some judges are real feisty like that, and they don't care that there's bad traffic or that you were stuck on the bus and that the bus was running late. So don't be late, because they can order you removed in your absence in absentia. And that's really scary. And that causes so many problems for people. But the reason a lot of people don't want to go to court is they think they're going to get taken and deported that same day. And that's not the case. So if you are out of immigration court, or even if you're detained, like if you're in a detention center, they won't deport you that same day unless you ask them to. Because you have what's called, whether you're in the detention center or whether you're out of the detention center, you have a right to an appeal, and you have 30 days to file that appeal. So even if they tell you, I'm really sorry, I'm not going to approve your case, you are ordered removed, you have 30 days to file your appeal, or, to leave, basically. You will not be taken into ICE custody at your removal hearing unless there's some type of major criminal issue that's going on, in which case I would be very surprised if they hadn't already taken you into custody. In all my years and all the hearings I have ever done, no one has ever been taken into custody at their final hearing, or at any hearing for that matter. Okay. They will usually apprehend you, if they're going to do it, before court. They don't want to deal with that in court and cause like an absolute kerfuffle, like a total madhouse for all the people who are in court and scared of this very thing. It would be wild circumstances for that to happen. And so, of course, I don't know your circumstances because I'm doing a recording rather than a personal consultation with you. But I'm just saying, like, you're not going to get, I can't promise it with certainty, but I can say with like, I've never, ever heard of it and I've never seen it happen. And I'm sure immigration lawyers are going to come for me in the comments on this, but it's just not a thing. It's not a thing that happens commonly to the extent where people feel, they feel so scared that I'm going to get deported today. You're not going to get deported today. You're not going to get deported at court. You may be ordered removed. The judge may say you have 30 days to either appeal or leave, but we file the appeal and you're good to go for many, many years. Okay. So I hope this is helpful. Again, my name's Hillary. I'm an immigration lawyer, and I would love to help you in any way. You can contact me at New Frontier Immigration Law. But if you take nothing else away from this episode, please go to your immigration court hearing. I know it's a nerve-wracking experience because I've seen so many clients go through it, but go with an immigration lawyer who you feel confident with, someone who shows up on time, someone who prepares you beforehand so you know what's going to go on. And with a really good immigration lawyer, all you have to do is say one word, yes. The judge will ask you, is your name your name? You say, yes. I see that so-and-so, Hillary Walsh, is sitting next to you. Do you want her to be your lawyer today and speak on your behalf? Yes. And then you just sit back and you don't have to say anything else. That's what a really good immigration lawyer will do for you. It will give you that peace of mind that you don't have to worry about anything other than just getting through the experience. Reach out to me if you need any help, my friend. Thanks so much.